Does your wealth align with your values? In what ways does your wealth affect your decision making? How does wealth impact your family dynamics? These are the big questions we'll help you answer on your road to wealth savviness. Join Amar, Shah, and his guest experts in the Savvy Wealth Podcast as they share insights and stories to help align your wealth with your values and family dynamics.
So how's it going?
It's going well, Amar.
Good. And for the people that are watching that don't know, this is Jennifer. She's an estate planning attorney. And how did you decide to become an estate planner?
So that's kind of an interesting story. I was not one of the people who grew up always wanting to be an attorney. Ended up in law school and started my career at a large law firm here in San Diego. And they forced or required all the first-year associates to rotate among various practice areas. And so I really did not go in having an interest in estate planning, but I did some work as a first-year associate in the estate planning group, and I loved it. And just kind of happened upon a great area of the law and a great group of attorneys. And after my first year, I joined that particular practice group.
Cool.
But I find it's a really practical area of the law. If anyone's experienced a death of a family, friend, anything like that, it's practical. I can do it anywhere. I can do it in a small town, big law firm, small law firm. So it's a great area of the law.
Yeah, and you probably definitely see the impact that you have on clients, right?
I do, yeah. So it sounds cliche, but as an attorney, I feel like I truly am helping people. I'm not really involved in the adversarial part at all. I'm meeting with clients. I'm hearing a lot of confidential and sometimes emotional aspects of, I have this son or daughter who has XYZ problems. What do we do? And so I do feel like I'm able to help people kind of come up with solutions or plans with the hope that everyone will get back on track and we won't even need any of these, particular provisions we put in place. So
makes sense, yeah. And so you started your own firm, or how did that transition?
Yeah, so again, I was at a big law firm for the first 8 years of my practice, and then I joined a small boutique estate planning firm, trying to get away from kind of the big firm lifestyle, going someplace smaller. And then that law firm started growing in areas outside of estate planning. And so my law partner, Phil Sullivan, and I decided now's the time to see if we can do it, the two of us. So we started this firm in December 2015. So
wow.
I know. So
4 years, almost like your 5-year anniversary, right?
I know. We celebrate that every year.
Oh,
so
cool.
It's been exciting and fun. So yeah.
Is there any challenges in estate planning that like being an attorney that you see that come up?
Yeah, so challenges are the law keeps changing. So so I meet with clients all the time and we try and do tax planning based on the tax laws we have in place. But tax laws change. And the tax laws we have in place are set to sunset on January 1st, 2026.
2026,
and
right?
So, I'm meeting with clients now and they're putting plans in place that work right now, knowing that it's going to be changing.
Yeah.
And so that is a challenge. And we always joke, don't shoot the messenger. This is not what we're setting
it's
up.
Congress.
But yeah, it is Congress. Government can't seem to get their act together, but we'll see. And tax acts, because they're expensive, you tend to only see them last for a period of about 10 years. And so we're always going to be dealing with the potential change in the tax laws. So that's definitely challenging. And also it's just challenging for clients to try and figure out what the best solution is if they have either difficult or kind of problematic family situations.
Yeah.
And so and there's not one size fits all. It's not a fill in the blank sort of form or process that we do here, because every family situation is unique.
It's unique, yeah. And I think that's it's a theme that repeats a lot, especially on our podcast here, is that family dynamics, correct, your values have to be integrated into your wealth planning, whether correct, that's estate planning, financial planning, correct, income tax planning. And so that's great. So today what we hope to do is talk a little bit about probate and why you want to avoid probate. Yes. Most families avoiding probate is definitely in their best interest. And there could also be some situations why you may want to go in probate, right? And so we can talk a little bit about that. And then what is a basic trust? What are the documents that are in a trust? And why is a trust important? And I want to make sure that it's clear that, Jennifer, you practice law in California, right?
I do. So so today I'm going to be talking about the probate process here in California, as well as trust and estate planning specific to California. What I'm talking about today is not necessarily the case in other states. In fact, probate administrations in other states, it's a very simple process. So in general, probate is a court supervised process where a decedent's assets are distributed out to beneficiaries. If they have a will in place, it'll go based on the will document. If they don't, then it'll go based on the laws in place. So here it'd go based on the California Probate Code. Other states, again, have a really simple process where the executor goes in, they're sworn in, they're appointed, and then the court never sees them again. Whereas here in California, it can be a very time-consuming and expensive process.
Yeah, so I remember, so when I was an advisor about 8 years ago, we used to have multiple courts for probate, right?
Here in San Diego. Correct.
We had downtown.
And North County. So Vista was the other courthouse. That has since closed. So there's no North County courthouse well, there is, but not for probate. And it's all downtown. And for a while, we only had 2 judges. They actually recently added a 3rd judge. But the calendar is busy. So, so you could have a very straightforward probate administration where it's a simple house, residence, and an investment account, and that's it. And that will take at a minimum a year to a year and a half to get wrapped up.
Yeah, and this could be a situation like if you have family dynamics and you have your children or somebody living in your house, there could be some issues there, right?
Correct. Well, and the other thing with probate is it's a matter of public record. So if you have a probate administration here in the San Diego courthouse, anyone can go down and say, I'd like to see a copy of the records. Whereas if you go the trust route, that's private. That's not subject to anyone's knowledge or review. It's a wonderful, among other things, part of having a trust in place.
Yeah, that's key because a lot of things, like when you have significant wealth or your family of wealth, there's also this timeline of when do you tell your family about your wealth. I mean, they know to a certain extent, but when do they know of the wealth and what your plans are? Yeah. And a lot of time there's friction that could happen when beneficiaries are assuming certain things and parents haven't explained what their intent is, right? And there could probably be more issues like that in probate.
Yeah, and again, then you're dealing not only with the family dynamic, but you're also dealing with the judge who has a busy docket and a busy calendar and does not have the same perspective that the family members necessarily do. Sometimes that's great. Sometimes it's good to have a neutral party. But other times it just further complicates the already complicated process. So we try very hard here in California. Sometimes it happens though anyways. We could have a great trust in place and beneficiary designations are completed and we'll still have to do a probate administration. So.
And why would that be? Can you think of an example?
Sure,
Because I think that's what helps.
So I have worked with clients. We've put a trust in place. We've funded it with a residence. And then they, 5 years later, I'll do it as an individual, 5 years later, decide to refinance. Bank says, I don't like dealing with trust, take it out of the trust, let's complete the refinance, and then the house is never put back in the trust.
Back in the trust, right?
Correct. So from my perspective, it's done, but things happen subsequently where you have to take the asset out of the trust. Yeah. Another example is you have a trust that's fully funded, it's great, all the assets are in there. You also have a retirement account, okay? You don't complete the beneficiary designation. Yeah. That will trigger a probate, even though you have all your other assets in the trust.
Yeah, and so it's important to notice that most assets transfer by operation of law.
Correct.
There are assets that transfer by operation of contract, right?
So those beneficiary
so those would be like IRAs,
correct.
like life insurance policies where you have a named beneficiary.
Correct. Pay on death,
pay on death
accounts.
Yeah, so you can also have bank accounts that have TOD or POD. That wouldn't apply to the trust document.
Correct.
Right?
They go outside of the trust agreement.
Yeah. And sometimes that could be good because there's immediate transfer.
Correct.
But sometimes that could be bad. And could you give an example? Like maybe, I know I've had to deal with this with some clients where they haven't passed away, but they've grown older and they need help.
Correct.
Right.
Yeah.
And so how does somebody help like an elderly parent if they're not titled in like trust and stuff like that?
So, so the great thing about transfer on death or pay on death accounts is it's simple. Okay. So a client loves it. They go into the bank, they complete a simple contract, and they're done. What they're not thinking about, which is what you raise, is that will trigger at their death. What happens in the event they become incapacitated? That's the great thing about a trust, is a trust will have provisions in place dealing not only with what happens at your death, but also what happens if you become incapacitated and can no longer manage your financial affairs. And so a transfer on death, pay on death account won't deal with those sort of scenarios. And so in that situation, you absolutely want to make sure your client has at least a financial power of attorney, so that if they do become incapacitated prior to their death, you have someone in place who can help you kind of manage your financial affairs. That's a minimum. Alternatively, you have a trust in place. So if you have a trust in place, that manages all your trust assets. You don't deal with the pay on death or transfer on death accounts. You move all those bank accounts to the trust. That'll deal with incapacity and those sort of scenarios, because it's critical to have someone in place who can act for you. We're all living longer and...
Yeah, and it's a key distinction, because like we have lifespan and we have health span.
Correct.
And healthy years can be X and lifespan could be Y.
Correct.
And so in that difference, you could need some more help.
Correct.
Right.
Yeah.
And you want to have the documents while you have all your marbles to while you can decide who's there to help you.
And we always hope that the situation is such where you get to that point in time where you feel like, okay, now's time where I need to start handing over the reins a little bit, but that's not always the way it works out. You know, sometimes something happens, you have a stroke, you have a heart attack, you become incapacitated, and there's no one in place. And in those scenarios, you have to go to court and have a conservatorship put in place. And that is an even more cumbersome and complicated process than probate.
So what is that? Well, I guess that could be a whole separate topic in itself, but like, what is basic conservatorship? Like, what does that mean?
So a conservatorship here in California is basically a petition is filed claiming that an individual no longer has the ability to make decisions for himself or herself, either personally and or financially. And so you can imagine a judge is going to go into a conservatorship proceeding very cautiously, because they are determining that that individual can no longer make decisions for themselves.
Does that individual have to come to the court?
So it depends on their health situation, but yeah, typically that individual will come, and it's typically filed by another family member who is hoping to be appointed conservator of the conservatee. But doctors are involved. It's a very specialized and complicated area of the law. And again, it makes sense, because you never want an individual's ability to be removed unless it's absolutely necessary. And so they're very cautious. And the process is slow, because they want to make sure they're crossing all their T's and dotting all their I's. So.
And that's good to know that the process is slow, because like, you know, they're doing their due diligence, but if the individual in themselves needs help.
Correct. It's not fast. It's not, if you have, things that you need to get done, it's really up to the kindness or the generosity of other family members to proactively take care of that for you. And that's not necessarily ideal. So I know I was involved in a conservatorship where a mom had a massive stroke and then suddenly was unable to handle her affairs, and her 3 kids had no idea what to do and how to run her business, or even what her assets were, or her debt obligations, and it has, I think we're in our 5th year now, but it's been a process. And again, it's a matter of public record. So, that's things
and that's got to be very stressful on the family, right?
Yeah,
because
you're already dealing with a difficult situation, because here's a parent who, 1 minute was healthy and strong and vibrant, and the next was completely debilitated. So
there are a lot of emotions going through this process, and so it's so this is probably a good segue of like So what is a trust? And how does it avoid probate? Or does it avoid probate?
So the goal is to make sure it avoids probate. And if it's properly done, it does in fact avoid probate. So a trust is basically an agreement where you are transferring assets that you own into a trust, and you yourself are still your own trustee. So we're not changing your control or management of those assets, but they're put in a trust structure to avoid probate administrations. And again, they'll include provisions dealing with, I'll control it as long as I can, but if I no longer have the ability or capacity to make decisions, then my successor trustee is going to step in and continue to use my assets for my comfort, my health, my maintenance, my support. And then it'll also include provisions as far as what happens at your death. So if it's spouses, what happens when first spouse dies and how are the assets administered? And then what happens at second spouse's death. For an individual is just what happens to the assets at my death. So it will include provisions for all of those eventualities, maybe all the way to your grandchildren's. And they may not even be, you may have a 2 and a 5-year-old child, and we're still going to include provisions dealing with grandchildren. So
let's maybe talk about the core documents. So there's there's a trust itself.
Yep.
And then there's a pour over will.
Correct. Yeah.
And so what does the pour over will do that's different?
So everyone still needs a will. It's just what that will say is, rather than the will including all of your dispositive provisions, meaning what happens and when my kids get the assets, the only distribution provision will say, give any assets that are a part of my estate to the trustee of my trust. And so that's why they're commonly referred to as pour over wills, because they take your estate assets, or your assets just in your individual name, and pour them over to your trust. So it helps coordinate your estate plan.
Perfect.
So you spend all this time working out these beautiful trust provisions, and you have an outlier asset that you didn't transfer in, it'll still be distributed.
Yeah. So how I think of it is just like gathering everything that's not in the trust, right?
Correct.
And putting it in the trust.
Correct.
Okay, cool.
You're pouring over your assets into that trust.
Yeah.
So.
And so what else is there? There's a healthcare directive?
Yeah, so part of your coordinated estate plan is a revocable living trust, pour over wills, healthcare directive.
Okay,
so,
and the healthcare directive is for?
So an advanced healthcare directive is basically who will be making medical decisions for me in the event I become incapacitated. And you can have a line of succession for that, as well as important medical decisions or preferences that you have. And common provisions we see are organ donations. I want them, I don't want them, I want them, but I want them limited to transplant, or I want them and I'm fine with them being broad. We'll include provisions about a discretionary autopsy. Are you comfortable with your agent having the discretion to authorize an autopsy when one is not required by California law?
Okay. So this is not like end of life planning, or
it's
or
similar,
like,
but it's devoted simply to medical decisions and kind of personal care decisions around your health.
So kind of like, should we pull the plug, or like should we save mom's life?
Correct.
Like,
So
it's kind of like
extraordinary
how long
measures. Correct. So will nutrition and hydration be withdrawn in certain circumstances, and what are those circumstances?
Okay.
So yeah, it's all the decisions around your medical preferences. And I have clients who I meet with all the time, and they're like, I don't really care. And, I point out that the name of the document is, it's a directive. You're directing what your wishes are. And if you don't care, then we'll make it loose. But this is your opportunity to tell whoever is going to be stepping into your shoes what your preferences are.
And then the person that's stepping into your shoes is probably really stressed.
Correct.
I know I personally have gone through this with my family, but like, what does the hospital do? Well, the hospital ask for this document.
Correct.
Like, do you have a healthcare directive? Do you have, and if you don't have a directive, then who decides?
So if you don't have a directive in place, then the hospital will normally go to your heir-at-law, so your next in line. So if you're married, it'll be your spouse. If you're not married but you have children, it'll be your children. But what you run into if you don't have a designated person in place, if there's a disagreement between your heirs or your next in line from family members, then that can critically slow your medical procedures.
Yeah, and I think I remember, I want to say Terry Schiavo. Was it kind of like a case like this where like mom wanted something and the husband wanted something different.
Correct.
And so now you have these two family members that are fighting over the
Correct.
medical care.
Correct.
Yeah.
So if you set out in the document who you want to make your decisions and what those decisions are, it's a very powerful and helpful document. I also find, in particular with parents who are selecting children as their agents, going back to what we talked about earlier, there's an emotional component. You have a parent who is sick and potentially dying in a hospital, and you have a document in place where that parent told you, I do not want extraordinary measures. Please stop. Then that actually gives the child, who is already dealing with an emotional situation, some clarity that they are fulfilling
what mom or dad wanted.
And that helps, I think, alleviate a little bit, not all of it, but a little bit of the stress and emotional component of it, because they're fulfilling their loved ones' final wishes. And I think that's important.
Yeah, definitely. And I think when you look at these medical decisions, like there's so many different choices, and like there's so many different circumstances that can happen, right?
Correct, yeah.
So like it's probably not something that's done like with like Mad Libs where you fill out like yes, save my life, or no. It's like more detailed than that, right?
It can be. And, unfortunately or fortunately, medicine is changing lightning fast these days. And so certain scenarios that may be appropriate now or may be of a concern now may not be 5, 10, 15, 20 years. And so I always recommend, keeping at least your basic preferences in the document, but having really frank conversations with your agent who you've selected.
And that's key.
As far as what you would like them to do or what you would choose for yourself. And it may not be the exact scenario, but the more conversations you have I think the more comfort you're giving your agent that they are making the decisions.
The right decisions for
that
you.
you would make for yourself. But without having those important conversations, they may not have that information.
Yeah. So it's key to have those conversations on an ongoing basis, right? Because like your attitude towards things may change.
Correct.
Right?
Correct. Exactly.
That's good. And so is there also a living, so we talked about healthcare directives, there's also power of attorney.
Correct.
Right?
So your financial power of attorney is kind of that fourth critical document of a coordinated estate plan. And that is only effective while you're alive, and will only deal with non-trust assets, as well as other kind of financial related matters. So examples are filing personal income tax returns. That's something that we can't transfer to your trust. It's something you only can do in your individual capacity. So you want to designate your attorney in fact who can do that.
That's a good thing to bring up, because as my clients get older, and when we look at clients that are in their late 80s and early 90s, and even older than that, the ability to meet with the CPA and it just becomes so cumbersome. Correct. That this power of attorney, they could actually do some of this work for their mom and dad.
Correct.
Or whoever they've
it is supposed to make your life easier. And we typically see the same individual who's listed as your successor trustee, as your executor in your will, and as your attorney in fact on your financial power of attorney, because you want the same person managing your property across the board, whether it's a trust asset, a non-trust asset, paying your credit card bills, paying your AT&T, account. All of that is something that's not necessarily tied to your trust, but is still an important part of making sure your life continues, even if you can't make those decisions.
And that's great. Maybe we can do another video on just like how do you find a good trustee or a good executor to be in your documents.
It can be very difficult, but it's such a critical and important question to have answered.
Yeah, no, I agree. So is there anything else that we didn't cover that's in this trust document? So we got healthcare directives, power of attorneys. What about, do I want to be buried or cremated? Where would we find that?
So that is typically in your healthcare directive. Okay. So we will include your preference as far as your remains. So I have some clients who are really detailed about what they want done. I have some clients who say, you know what, I'm just going to leave it up to the discretion of my agent and kind of deal with that separately. But to the extent they have a preference, we build that into the healthcare directive.
Perfect. And there could be situations like that you want to transfer values through a trust, right? Like if you're charitably inclined, I want my kids to continue to be charitably inclined. Or if I want my kids to continue to work hard. I've heard of this, like some people have done a W-2 matching, like whatever your
matched earned income.
Whatever your. So describe that so people understand. Like, so a trust is not only to simplify the process, but also to influence your values, not just transfer money.
Potentially, yeah. So in the trust agreement, as I mentioned, you're going to have provisions in place dealing not only with while you're alive, but also what happens to your assets at your death and how those beneficiaries are going to receive those assets. And you can make it simple, meaning my beneficiaries are just going to get those assets outright and free of trust, so no control. Or I'm going to have those beneficiaries receive these assets, but they're going to receive it in a trust structure that I'm putting in place inside that trust agreement. And you can include any number of bells and whistles as far as matched earned income is a great example. I want the trustee to make distributions based on what that beneficiary is earning on their own, in the hopes that you're inspiring and motivating them to continue to have their own
to have gainful employment
income. Correct. So we don't want trust fund kids. If there are substance abuse issues, you can build provisions in place saying, you know, they need to do XYZ before they can receive the assets. You can make them still relatively simple, so it's there for their health, their support, their maintenance, but maintenance and support will include things such as making a reasonable down payment on a residence, buying an automobile, helping them get involved in a new business adventure or professional career. So again, it's a way for you to promote what you think is important right in the trust agreement. But we can also give flexibility for changes down the road through a letter of wishes. So you have provisions in place that say, I want that for their health, support, maintenance, and education. But I direct my trustee to review any letter of wishes or instructions I've left. It's not a requirement, it's only precatory, but it will give the trustee an idea of what you believe is appropriate under the guise of maintenance and support. And will allow you informally to change that over time. So I think, again, it can be flexible and changing over time, but again, the trustee as well as the beneficiaries will know kind of where what you were prioritizing and where you want to see the beneficiary going. Correct. Kind of your legacy, I guess, is the way. Or I want beneficiary to be able to give a certain percentage of the assets to charity. Charitable giving was important to me. I want that legacy to continue.
And I guess like there would be also another part of the values piece of like, could this be ongoing, or is this just at one time at distribution? So
no, so you can build a trust in place that will last the lifetime of the beneficiary, and then will distribute at that beneficiary's death. So you can build that in. Certain states here in the U.S. Allow perpetual trust, meaning they can go on forever. California does not. So so here in California, we tend to see trusts that last maximum about 100 years. So it'll be your generation, your child's generation, and likely your grandchild's generation. But after that, it'll
and then
stop.
Finally distribute.
Correct.
Okay. What if I have like collectibles, or if I have like earrings and I only have like one son or something? Like, how would you assign things? Because you can't put your like a car into a trust, can you?
Sure. Yeah, you absolutely can. So, so with clients of ours, we'll do a general assignment of their tangible personal property. We do include cars, even though those have a separate form of title, only because people tend to want to avoid going to the DMV. But you can't take title in a trust for your car. But we'll do a general assignment of all those items. They tend to be items that you can't transfer otherwise. And inside the trust, we'll allow each of our clients to do a separate list or memorandum designating certain items to go to certain beneficiaries. So rather than including that in the actual trust, you can do it through a separate document. Again, going back to that flexibility, if they want a certain item of works of art, jewelry, whatever it may be, to go to certain individuals, they can do that. If not, we'll allow the trustee typically to either sell the assets and then the sale proceeds will be distributed to certain beneficiaries, or donate any items that cannot be reasonably sold. So we'll build those provisions in, but I find clients tend to like that control in their hands. They tend to be sentimental items more than high value, fair market value items. And so we always build that into our trust documents.
Perfect. Is there anything else that you think we should go over?
No, I think for
pretty much the basics,
that
right?
is the basic kind of coordinated estate plan here in California, and again, working towards avoiding any sort of formal probate administration.
So like just to summarize, is like you want to avoid probate because it takes forever and it makes everything public.
Correct.
And conservatorship, you just want to avoid.
Correct.
A lot of emotions, a lot of same concepts.
It's time-consuming. It's a matter of public record. It's just not anything you want to be forced to be a part of here in California.
And the big thing with trust is that you have to fund your trust, right?
Correct.
You can't just have trust documents. You actually have to fund your trust.
Correct.
And the trust is basically a vehicle to avoid probate and to also get healthcare assignments, what you want.
So those will be in a separate, so your trust will deal with your trust property. You'll have 3 separate documents.
3 separate documents in the revocable living trust, right?
The 4 separate documents. You have your trust agreement that will deal with your trust property. You're going to sign and execute a separate will that'll deal with only estate assets. You're going to sign a separate healthcare directive that deals with medical decisions, and a separate financial power of attorney that deals with non-trust assets and kind of financial related matters. But those will all be 4 separate documents.
Perfect. Yeah. So how do people find you, or how do, like, if they want to contact you? Or...
So we have a website. Again, my name is Jennifer McGibbons. My law firm is Sullivan, McGibbons and Associates. And our website is smalawsd.com. So you can find all of my contact information.
Thank you for listening to the Savvy Wealth Podcast. Click the subscribe button below to be notified when new episodes become available. The opinions expressed in this program are for general informational purposes only and are not intended to provide specific advice or recommendations for any individual or on any specific security. It is only intended to provide education about the financial industry. To determine which investments may be appropriate for you, consult your financial advisor prior to investing. Any past performance discussed during this program is no guarantee of future results. Any indices referenced for comparison are unmanaged and cannot be invested into directly. As always, please remember, investing involves risk and possible loss of principal capital. Please seek advice from a licensed professional. Client First Capital, LLC is a registered investment advisor. Advisory services are only offered to clients or prospective clients where Client First Capital, LLC and its representatives are properly licensed or exempt from licensure. No advice may be rendered by Client First Capital, LLC unless a client service agreement is in place.